Hello everyone, welcome back to the channel. My name is Varun Kaushal and I'm a legal intern at LEXIS and Company. Today we are going to discuss about the topic powers of police to arrest without a warrant. The provision of arrest is given in the chapter 5 from section 41 to section 60 of the Code of Criminal Procedure 1973. This chapter deals with provisions of arrest of persons and the right of arrested persons. Questions like how arrest is made, who can arrest, can a police officer make an arrest without warrant or without order of a magistrate, can a magistrate himself make an arrest, what are the rights of an arrested person, what are the procedures regarding arrest in different circumstances, etc. have been answered in the said provisions. In this video, I will be dealing with the primary question: when can a police officer arrest without warrant or without an order of magistrate? According to section 273 of CRPC, evidence of the trial and other proceedings shall be taken in the presence of the accused. In order to follow the said procedure, the trial before the magistrate commences when the accused appears before the magistrate. Accordingly, the attendance of the accused can be secured by his arrest. Thus, arrest is the first step in the process of investigation and trial after complaint. Arrest of a person can be effected in two ways: with a warrant, without a warrant. Conclusively, arrest can be understood as the deprivation of a person at his liberty by legal authority or at least by an apparent legal authority. According to the legal glossary, Government of India, arrest means that the restraining of the liberty of a person in order to compel obedience to the order of the court of justice or to prevent the commission of the crime or to ensure that a person charged or suspected of a crime may be forthcoming to answer it. Now we will be talking about when a police officer may arrest without a warrant. Section 41 of the CRPC deals with the main situations when a police officer may make an arrest without a warrant or without an order of magistrate. A police officer may arrest any person, number 1, who commits any cognizable offense in the presence of that police officer, number 2, against whom reasonable complaints are made or credible information has been received or reasonable suspicion exists that he has committed an offense punishable with 3 to 7 years imprisonment of either description with or without fine, provided that the police officer have reasons to believe that such person has committed the said offense, is satisfied that arrest is necessary to prevent further commission of offense or for proper investigation or to prevent tampering of evidences or to prevent threat, inducement, etc. to witness or to ensure his presence, that he has committed an offense punishable with more than 7 years imprisonment of either description with or without fine, of life imprisonment or death sentence, provided that the police officer have reasons to believe that such person has committed the said offense. Number 3, who is the proclaimed offender. Number 4, who has or is suspected to have a stolen property in possession with a lawful excuse. Number 5, who obstructs an on-duty police officer or escapes or attempts to escape from legal custody. Number 6, who is deserter from armed forces. Number 7, who has committed an offense outside the Indian territory, but if done in India would have been punishable under any enactment, thus subjected to laws of extradition. Number 8, who, being a released convict, breaches any rule stated under subsection 5 of section 356 of CRPC. Number 9, against whom a requisition in which all the details of the offender to be arrested are mentioned along with the cause of the arrest has been made to this police officer by another police officer who is authorized to arrest that person without a warrant. This is to be noted that if the police officer makes or does not make any such arrest, he must record the reasons of his act in written. Section 42 states situation when a police officer is authorized to make an arrest with a warrant or order from magistrate. This section authorizes any police officer to arrest a person who commits a non-cognizable offense in presence of that police officer and denies to give his name and residential address or gives false name and residential address to police. Such arrests may be made in order to ascertain the real identity and address of the said person. Other cases when a police officer is empowered to make an arrest without any warrant is like arrest to prevent the commission of an offense, which says section 151 empowers a police officer to arrest any person who is designing to commit any cognizable offense which cannot be otherwise prevented. Number 2. Section 432(3) lays down the provision that any person whose suspension or remission of sentence has been cancelled can be arrested by a police officer without any warrant or order from magistrate. Number 3. For the purpose of maintenance of public order and tranquility, any executive magistrate or police officer may arrest any person without warrant if such person forms a part of any unlawful assembly and does not disperse or shows determination to not disperse when commanded by such magistrate of police officer in charge as per the section 129 chapter 10 of the Code of Criminal Procedure 1973. Number 4. Subsection 3 of section 122 empowers a police officer to arrest a person whose conditional order of discharge has been cancelled under subsection 5 of the section 123 of CRPC. The provision of section 438(1) of CRPC empowers the officer in charge of police station to arrest a person without any warrant if the court has not entertained his application of anticipatory bail or for a non-bailable offense. That's it for today's video. If you have any question regarding the video, please do ask in the comment section. Thank you for watching the video. Please don't forget to like, share and subscribe our channel LEXCLIQ.